Hello and welcome to the Entrant. The topic for today's discussion is one of the most relevant topics under the civil law. The general defenses under tort holds great importance when it comes to questions asked in competitive exams. Before getting into the various defenses, let us understand a little about them.
Meaning of general defenses. When a plaintiff brings an action against the defendant for a tort committed by him, he will be held liable for it if there exists all the essential ingredients which are required for that wrong. But there are some defenses available to him using which he can absolve himself from that liability arising out of the wrong committed. These are known as general defenses in the law of torts. They are volunty non fit injuria or the defense of consent, where the wrongdoer is the plaintiff. It is a case of inevitable accident, an act of God, or private defense, or mistake, necessity, or has been legalized under statutory authority. In case a plaintiff voluntarily suffers some harm, he has no remedy for that under the law of torts, and he is not allowed to complain about the same. The reason behind this defense is that no one can enforce a right that he has voluntarily abandoned or waived. Consent to suffer harm can be expressed or implied. If one has agreed to a surgical operation, then he cannot sue the surgeon for it, and a player in the games is deemed to be ready to suffer any harm in the course of the game. Similarly, a spectator in the game of cricket will not be allowed to claim compensation for any damages suffered in the course of the game. For the defense to be available, the act should not go beyond the limit of what has been consented, and it is important to show that the consent of the plaintiff was freely given. In cases where the plaintiff himself is the wrongdoer, the maxim extirpe causa non oritur actio, which translates to from an immoral cause no action can arise. If the basis of the action by the plaintiff is an unlawful contract, then he will not succeed in his action and cannot recover damages. If the defendant asserts that the claimant himself is the wrongdoer and is not entitled to the damages, then it does not mean that the court will declare him free from the liability, but he will not be liable under this head. In the case of Pitts versus Hunt, there was a rider who was 18 years of age and was encouraged his friend, who was 16 years old, to drive fast under drunken conditions, but their motorcycle met with an accident. The driver died on the spot. The pillion rider suffered serious injuries and filed a suit for claiming compensation from the relatives of the deceased person. This plea was rejected as he himself was the wrongdoer in this case. Inevitable accident. An accident means an unexpected injury, and if the same accident could not have been stopped or avoided in spite of taking all due care and precautions on the part of the defendant, then we call it an inevitable accident. It serves as a good defense as the defendant could show that the injury could not be stopped even after taking all the precautions, and there was no intent to harm the plaintiff. In the state of Assam State Corporation, etc. Federation Limited versus Srimati Anubha Sinha, the premises which belonged to the plaintiff were let out to the defendant. The tenant, that is the defendant, requested the landlord to repair the electric wirings of the portion which were defective, but the landlord did not take it seriously and failed to do so. Due to a short circuit, an accidental fire spread in the house. No negligence was on part of the tenant's side. In an action by the landlord to claim compensation for the same, it was held that this was the cause of an inevitable accident and the tenant would not be held liable. An act of God. The defense of act of God and inevitable accident might look the same, but they are different. Act of God is kind of an inevitable accident in which the natural forces play their role and cause damage. For example, in the case of heavy rainfall, storms, tides, tsunamis, etc. The essentials required for this defense are that the natural force is working and that there must be an extraordinary occurrence and not the one which could be anticipated or guarded against reasonably. In the case of Ramalinga Nathar versus Narayan Reddy, the unruly mob robbed all the goods transported in the defendant's lorry. It was considered to be an act of God, and the defendant, as a common carrier, would be compensated for all the loss suffered by him.
The law has given permission to protect one's life and property, and for that it has allowed the use of reasonable force to protect himself and his property. The use of force is justified only for the purpose of self-defense and the presence of an imminent threat to a person's life or property. The force used must also be reasonable to repel the imminent danger. For the protection of property also, the law has only allowed taking such measures which are necessary to prevent the danger. In the case of Ramanuja Mudali versus M. Gangan, a landowner, that is the defendant in this case, had laid a network of live wires on his land. The plaintiff, in order to reach his land, tried to cross his land at 10 p.m. and received a shock and sustained some serious injuries due to the live wire, and there was no notice regarding the same. The defendant was held liable in this case, and the use of wires is not justified. Mistake. The mistake is of two types, mistake of law and mistake of fact. In both conditions, no defense is available to the defendant. When a defendant acts under a mistaken belief in some situations, then he may use the defense of mistake to avoid his liability under the law of torts. In the case of Consolidated Company versus Curtis, an auctioneer auctioned some of his goods of his customer, believing that the goods belonged to him. But then the true owner filed a suit against the auctioneer for tort of conversion. The court held the auctioneer liable and mentioned that the mistake of fact is not a defense that can be pleaded in this case. Necessity. If an act is done to prevent greater harm, even though the act was done intentionally, is not actionable and serves a good defense and must be distinguished with private defense and an inevitable accident. The following points must be considered. In necessity, the infliction of harm is upon an innocent, whereas in case of private defense, the plaintiff is himself a wrongdoer. In necessity, the harm is done intentionally, whereas in the case of an inevitable accident, the harm is caused in spite of making all the efforts to avoid it. For example, performing an operation of an unconscious patient just to save his life is justified. In the case of Cope versus Sharp, the defendant entered the plaintiff's premises to stop the spread of fire in the adjoining land, where the defendant's master had the shooting rights. Since the defendant's act was to prevent greater harm, he was not liable for trespass. Statutory authority. If an act is authorized by any act or statute, then it is not actionable even if it would constitute a tort otherwise. It is a complete defense and the injured party has no remedy except for claiming compensation as may have been provided by the statute. Immunity under statutory authority is not given only for the harm which is obvious but also for the harm which is incidental in nature. In the case of Hammersmith Rail Company versus Brand, the value of the property of the plaintiff depreciated due to the loud noise and vibrations produced from the running trains on the railway line, which was constructed under a statutory provision. The court held that nothing can be claimed for the damage suffered, as it was done as per statutory provisions, and if something is authorized by any statute or legislature, then it serves as a complete defense. The defendant was held not liable for the case. I hope this video was helpful in providing a simple and clear understanding of the general defenses to torts. For any further queries, please drop your questions in the comment box below. Please like and share the video and subscribe to our channel.